You've spent years perfecting your machine learning algorithms, but have you considered the legal implications of your training data? Many data scientists and AI professionals are unknowingly putting themselves and their companies at risk. In this video, we'll help you assess your own practices and understand the potential legal pitfalls in AI development. By the end, you'll have the knowledge to protect yourself and your work in the complex landscape of AI and intellectual property law. In the world of artificial intelligence, data reigns supreme. The insatiable appetite of AI systems for vast amounts of information has become a defining characteristic of modern machine learning. But just how much data does it take to train a state-of-the-art AI model? The answer is staggering. Today's most advanced AI systems require an almost unfathomable amount of data to achieve their impressive capabilities. We're not talking about gigabytes or even terabytes. We're in the realm of petabytes and beyond. To put this in perspective, a single petabyte is equivalent to 20 million four-drawer filing cabinets filled with text. Now imagine feeding that much information into a computer system, and you begin to grasp the scale of data consumption in AI training. This massive data requirement creates a significant challenge for AI developers and companies. High-quality, diverse datasets are essential for creating robust and accurate AI models. However, such datasets are increasingly scarce and difficult to obtain legally. This scarcity has led to a growing tension in the AI industry between the need for more data and the ethical and legal constraints on data acquisition. The pressure on AI companies to acquire more data is intense. In a field where the quality and quantity of training data can make or break a model's performance, there's a constant race to obtain larger and more comprehensive datasets. This pressure has driven many companies to explore alternative methods of data collection, some of which push the boundaries of ethical and legal norms. One such method that has gained prominence is web scraping. This automated technique allows companies to collect vast amounts of data from across the internet quickly and efficiently. Web scraping bots can crawl through millions of web pages, extracting text, images, and other digital content. While this approach provides access to a wealth of information, it also raises serious ethical and legal concerns. The ethical implications of using scraped data without consent are profound. Many creators and content owners are unaware that their work is being used to train AI systems. This lack of transparency and consent violates the principles of data privacy and intellectual property rights. Moreover, it raises questions about the fairness of using someone's creative work or personal information to develop commercial AI products without their knowledge or compensation. Despite these concerns, the practice of web scraping for AI training data has become widespread. Some of the most advanced language models in existence have been trained on enormous datasets sourced primarily through web scraping. For example, the Bloom language model, developed by the Big Science Research Initiative, utilized data from Common Crawl, a vast repository of web-scraped multilingual content. This approach allowed the developers to enhance language diversity and include low-resource languages in their model. The scale of data used in these models is truly astounding. We're talking about AI systems trained on billions of data points, encompassing everything from books and articles to social media posts and forum discussions. This comprehensive approach allows AI models to develop a broad understanding of language and context, but it also increases the likelihood of including copyrighted or sensitive information in the training data. As impressive as these data-hungry AI models may be, there are hidden costs to this approach. The quest for ever larger datasets is putting companies at significant legal risk. The lack of clear regulations and precedents regarding the use of scraped data for AI training has created a legal gray area that many companies are navigating without a clear roadmap. This legal uncertainty is compounded by the fact that many widely used datasets lack proper documentation regarding their licensed uses. A recent report revealed that 70% of commonly used datasets either lack information about permitted uses or are labeled as more permissive than the original author intended. This lack of transparency in data provenance creates a ticking time bomb of potential legal challenges for AI companies. Beyond the murky waters of dataset licenses lies an even more contentious legal battleground. What happens when AI's voracious appetite for information collides with centuries-old copyright laws? The courts are grappling with a question that could redefine the limits of machine learning. Can an AI system read a book without infringing on copyright? To understand this complex issue, we must first revisit the basics of copyright law. At its core, copyright legislation aims to protect the rights of creators and promote the progress of science and useful arts. It grants authors exclusive rights to reproduce, distribute, and create derivative works based on their original creations. This legal framework has served as a crucial foundation for intellectual property protection in the analog world. However, the advent of artificial intelligence has introduced unprecedented challenges to traditional copyright concepts. AI systems, with their ability to process and learn from vast amounts of data, blur the lines between consumption and creation. When an AI model ingests copyrighted material as part of its training data, is it simply reading the work, or is it engaging in unauthorized reproduction? This question becomes particularly thorny when we consider the concept of fair use in copyright law. Fair use allows for limited use of copyrighted material without permission under certain circumstances, such as criticism, commentary, news reporting, teaching, scholarship, or research. In the United States, courts evaluate fair use based on 4 factors: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect on the potential market for the original work. Applying these factors to AI training is far from straightforward. Proponents of AI argue that the use of copyrighted material in machine learning is transformative, adding new expression or meaning to the original works. They contend that AI-generated outputs are fundamentally different from the input data, and that the training process does not diminish the value of the original works. Critics, however, argue that AI training may constitute copyright infringement, especially when the resulting models can produce outputs that closely resemble the copyrighted materials used in training. The legal landscape surrounding this issue is rapidly evolving, with litigation increasing globally. Recent high-profile cases have brought these questions to the forefront. For instance, the ongoing litigation involving Getty Images and Stable Diffusion highlights the complexities of determining copyright infringement in AI training. These cases are forcing courts to grapple with novel questions about the nature of AI learning and its relationship to existing copyright frameworks. The concept of transformative use has become central to this debate. Courts must determine whether AI-generated outputs add sufficient new expression or meaning to constitute fair use of the original works. This assessment is highly context-dependent and can vary significantly based on the specifics of each case. The challenge lies in balancing the promotion of innovation with the protection of creators' rights in an era where AI can process and recombine information at unprecedented scales. Different jurisdictions are approaching these questions in diverse ways, adding another layer of complexity to the issue. In the United States, the interpretation of fair use in the context of AI training remains a contentious and evolving area of law. Recent litigation has highlighted the challenges of applying traditional fair use factors to the unique characteristics of machine learning processes. The European Union has taken a somewhat different approach. The EU provides specific exceptions for text and data mining that allow for automated analysis of copyrighted materials under certain conditions. However, these exceptions are not uniformly applied across member states, and rights holders have the ability to opt out of this usage. This creates a patchwork of regulations that AI developers must navigate carefully. Japan offers yet another perspective on this issue. The Japanese Copyright Act allows for text and data mining for both commercial and non-commercial purposes, provided the content is not used for enjoyment purposes. This approach reflects an attempt to balance innovation with the protection of creators' rights. However, even in Japan, contractual terms or technological protection measures may override these exceptions, adding further complexity to the legal landscape. The global nature of AI development and deployment further complicates matters. AI models trained in one jurisdiction may be deployed in another with different copyright laws, raising questions about cross-border enforcement and compliance. The EU AI Act, for example, imposes compliance obligations on AI model providers, even if their models were trained outside the EU, highlighting the potential for regulatory conflicts. This legal uncertainty has significant implications for AI developers and the future of machine learning. The lack of clear, consistent standards regarding the use of copyrighted material in AI training creates substantial risks for companies investing in AI technology. It also raises concerns about potential chilling effects on innovation if developers become overly cautious about using certain types of data in their training processes. While copyright battles rage on, another intellectual property right silently threatens to upend AI development. How can arranging facts become more valuable than the facts themselves? Enter the world of database rights, a lesser known but potentially game-changing factor in the AI training data landscape. The European Union's Database Directive, established in 1996, introduced a unique form of protection known as sui generis database rights. These rights go beyond traditional copyright law, safeguarding the investment made in compiling and organizing databases. This means that even if individual elements within a database aren't copyrighted, the structure and arrangement of that information can be legally protected. For AI developers, this adds another layer of complexity to the already challenging task of data collection. Imagine spending months meticulously gathering and organizing data for your AI model, only to discover that the very act of extracting substantial portions of that information could violate someone else's legal rights. This is the reality created by database rights, and it's forcing companies to re-evaluate their data scraping practices. The distinction between database rights and copyright is crucial. While copyright protects original creative works, database rights focus on the effort and resources invested in assembling and structuring information. This means that a collection of public domain facts, when organized in a particular way, could be off limits for AI training purposes if protected by database rights. Recent disputes have highlighted the potential impact of these rights on AI development. Consider the case of the Books3 dataset, a popular resource for training language models. It was alleged to contain over 170,000 pirated books, raising significant concerns about both copyright infringement and potential database right violations. Similarly, Google's C4 dataset, reported to contain data scraped from 15 million websites, faces scrutiny under these legal frameworks. These cases illustrate the growing tension between the data hunger of AI systems and the legal protections surrounding organized information. As AI models require ever larger data sets to improve their performance, the risk of infringing on database rights increases. This has led to a climate of uncertainty, with many companies unsure about the legal status of their data collection methods. The European Data Protection Board's establishment of a ChatGPT task force further underscores the seriousness of this issue. This initiative aims to address the challenges posed by AI-driven data scraping, signaling increased legal scrutiny of database rights and their implications for AI development. As regulatory bodies become more involved, AI companies may find themselves navigating an increasingly complex legal landscape. Experts in the field have noted that database rights can significantly impact AI development by restricting access to valuable datasets. The lack of clarity surrounding these rights can have a chilling effect on innovation, as companies may become hesitant to engage in data scraping due to potential legal repercussions. This caution could slow the pace of AI advancement, particularly in regions where database rights are strongly enforced. The economic rationale behind database rights, as highlighted in an OECD report, is to incentivize the creation and maintenance of databases. These structured collections of information are crucial for AI training, providing the raw material that machine learning algorithms need to identify patterns and generate insights. However, this protection can also lead to unintended consequences, potentially fostering monopolistic practices that stifle competition in the AI space. Consider a scenario where a company invests heavily in creating a comprehensive database of medical information. Under database rights protection, they could potentially restrict access to this valuable resource, limiting the ability of other AI developers to create innovative healthcare applications. This monopolization of data could concentrate AI advancements in the hands of a few large companies, potentially slowing overall progress in the field. As AI systems increasingly rely on vast amounts of data to function effectively, the potential for database rights to restrict access to essential training information raises concerns about the future of AI innovation on a global scale. Countries with strong database right protections may find themselves at a disadvantage in the AI race, as developers in these regions face additional hurdles in accessing and utilizing large-scale datasets. This situation creates a complex balancing act for policymakers and courts. On one hand, there's a need to protect the investments made in creating and maintaining valuable databases. On the other, there's a pressing need to ensure that these protections don't inadvertently hamper technological progress and innovation in the rapidly evolving field of artificial intelligence. The global nature of AI development further complicates this issue. With data flowing across borders and AI models being trained on information from around the world, how can companies ensure compliance with varying database right regulations in different jurisdictions? This question becomes particularly pertinent as AI systems become more sophisticated and require increasingly diverse and extensive datasets to improve their capabilities. As companies grapple with database rights across borders, an even more elusive form of protection lurks beneath the surface. The most valuable part of an AI system might not be its visible code, but the invisible data that shapes its intelligence. This hidden asset falls under the realm of trade secrets, a centuries-old legal concept that's taking on new significance in the AI era. Trade secrets encompass confidential information that provides businesses with a competitive edge. In the context of AI, this can include proprietary algorithms and, crucially, the training datasets that power machine learning models. Unlike patents or copyrights, trade secrets don't require registration or have a limited duration. They remain protected as long as they stay secret and provide economic value. The legal landscape surrounding trade secrets is complex and varies across jurisdictions, making it challenging to protect AI training datasets uniformly. This complexity is further amplified by the global nature of AI development, where data flows across borders and models are trained on information from around the world. Companies must navigate a patchwork of regulations to ensure their valuable datasets remain protected. Recent litigation has brought the importance of trade secrets in AI to the forefront. The tech industry has seen a surge in cases where companies face accusations of scraping data that may contain trade secrets. One notable example is Getty Images suing the creators of AI art tool Stable Diffusion for allegedly scraping its content. This case raises significant questions about the boundaries of trade secret protections in the context of AI training data. Tech giants like Meta and OpenAI have also found themselves embroiled in disputes where the datasets used for training their AI models were claimed to contain trade secrets. These cases have led to increased legal scrutiny over data acquisition practices in the AI industry, as companies invest heavily in developing proprietary datasets. The applicability of trade secret law to AI training data becomes increasingly significant. Trade secret protection offers several advantages over other forms of intellectual property rights. Unlike patents, which require public disclosure in exchange for temporary monopoly rights, trade secrets allow companies to maintain indefinite protection as long as they can keep the information confidential. This is particularly appealing in the fast-paced world of AI, where public disclosure could quickly render an innovation obsolete. However, maintaining secrecy in the collaborative environment of AI development presents unique challenges. The OECD report emphasizes that trade secret protections depend on the reasonable steps taken by the rightful holder to keep the information secret. In practice, this might involve implementing strict access controls, using non-disclosure agreements, and carefully managing partnerships and collaborations. For AI companies, treating datasets as trade secrets requires a delicate balance between protecting valuable assets and fostering innovation through collaboration. They must implement robust security measures to prevent unauthorized access or disclosure while still allowing their teams to work effectively with the data. This might involve sophisticated data management systems, strict internal policies, and careful vetting of external partners. The potential for trade secret law to protect AI innovations extends beyond just datasets. Proprietary training techniques, model architectures, and even the specific configurations used to achieve high-performance results could all potentially qualify as trade secrets. This broad applicability makes trade secret protection an attractive option for companies looking to safeguard their competitive advantage in the AI space. As the importance of data as a protectable business asset grows, we're likely to see a shift in AI business strategies. Companies may become more secretive about their data acquisition and curation processes, viewing these as key differentiators in the market. This could lead to increased competition for high-quality datasets and potentially create barriers to entry for smaller players in the AI field. The rise of trade secret protection in AI also raises important questions about transparency and accountability. As more companies rely on trade secret law to protect their AI assets, it may become more difficult for researchers, regulators, and the public to scrutinize AI systems for potential biases or safety issues. Striking a balance between protecting legitimate business interests and ensuring responsible AI development will be a crucial challenge for policymakers and industry leaders alike. The courtroom has become the new battleground for the future of AI, with landmark cases threatening to rewrite the rules of data scraping and model training overnight. As stakeholders clash in unprecedented legal showdowns, one lawsuit has emerged with the potential to transform the entire AI landscape and redefine the boundaries of fair use in the age of machine learning. At the heart of these legal battles lies a fundamental question. Does the use of copyrighted materials to train AI models constitute infringement? This issue has sparked a flurry of lawsuits from various parties, including authors, news organizations, and image providers. Each case brings its own unique set of circumstances and arguments, but collectively, they represent a crucial moment in the evolution of intellectual property law as it applies to artificial intelligence. One of the most closely watched cases involves the Authors Guild, which has filed a class action lawsuit against OpenAI. The authors allege that the company used copyrighted materials without permission to train its language models, including the popular ChatGPT. This case strikes at the core of AI development practices, challenging the legality of data scraping techniques that have become commonplace in the industry. The lawsuit raises complex questions about the nature of AI training and its relationship to existing copyright frameworks. On one side, OpenAI and other AI companies argue that their use of copyrighted materials falls under fair use doctrine. They contend that the process of training AI models is transformative, creating something entirely new and distinct from the original works. This argument draws parallels to previous legal battles in the early days of the internet, where courts had to grapple with applying copyright law to emerging technologies. However, the authors and their supporters present a different perspective. They argue that the wholesale copying and use of copyrighted works for commercial AI development goes beyond the bounds of fair use. The plaintiffs contend that AI companies are essentially free-riding on the creative efforts of others, potentially undermining the economic incentives for content creation that copyright law is designed to protect. The outcome of this case could have far-reaching implications for the AI industry. A ruling in favor of the authors might force AI companies to dramatically alter their data collection and training practices. It could potentially require them to obtain licenses for copyrighted materials used in training, significantly increasing the cost and complexity of AI development. On the other hand, a victory for OpenAI could cement the legal foundation for current data scraping practices, potentially opening the floodgates for even more aggressive data collection efforts. Beyond the realm of text-based AI, similar battles are unfolding in the visual arts domain. Getty Images, a major provider of stock photos and illustrations, has sued Stability AI, the creator of the popular image generation tool Stable Diffusion. Getty alleges that Stability AI scraped millions of copyrighted images from its database without permission to train its AI model. This case highlights the tensions between traditional content providers and emerging AI technologies that can generate seemingly unlimited amounts of new content based on existing works. The Getty Images lawsuit brings additional nuances to the copyright debate. Unlike text, where AI-generated content might be more easily distinguished from human-authored works, AI-generated images can closely resemble existing copyrighted images. This raises questions about whether AI outputs should be considered derivative works and whether they infringe on the copyrights of the original images used in training. As these cases make their way through the courts, legal experts are closely monitoring their progress and potential outcomes. Many believe that the rulings in these cases will set crucial precedents that will shape the future of AI development and its intersection with intellectual property law. The decisions could influence everything from how AI companies collect and use data to how they structure their business models and collaborate with content creators. The legal uncertainty surrounding these issues has prompted calls for clearer regulations and guidelines. Policymakers and industry leaders are grappling with the challenge of balancing innovation in AI with the protection of intellectual property rights. Some argue that existing copyright laws are ill-equipped to handle the complexities of AI and machine learning, suggesting that new legislative frameworks may be necessary. In Europe, regulators are taking proactive steps to address these challenges. The European Data Protection Board has established a task force specifically focused on addressing the issues posed by AI-driven data scraping. This move underscores the global nature of the problem and the need for coordinated international efforts to develop coherent legal approaches to AI and intellectual property. As the legal battles unfold, parallels are being drawn to past transformative moments in technology and copyright law. The current disputes echo earlier conflicts surrounding the rise of digital music sharing platforms and search engines. Those cases ultimately reshaped the interpretation of copyright law in the digital age and set important precedents for fair use in the context of new technologies. The outcomes of today's AI-related lawsuits could have similarly profound effects on the tech landscape. As the legal battles over AI and intellectual property unfold in the United States, a different approach is taking shape across the Atlantic. The contrasting strategies of the US and EU to intellectual property in AI could redefine the global landscape of innovation. But which side offers more freedom for AI development, and what are the implications for the future of this rapidly evolving technology? At the heart of the US approach lies the doctrine of fair use, a flexible concept that allows for limited use of copyrighted material without permission under certain circumstances. This doctrine is particularly relevant for AI developers who rely on large-scale data scraping to train their models. The fair use principle considers factors such as the purpose of use, the nature of the copyrighted work, the amount used, and the effect on the market for the original work. While this flexibility can be advantageous for innovation, it also introduces significant legal uncertainty. Courts in the US interpret these factors on a case-by-case basis, leaving AI companies in a constant state of ambiguity about the legality of their data practices. This uncertainty can lead to costly legal battles and potentially stifle innovation as companies become more cautious about pushing the boundaries of what's permissible. In contrast, the European Union has taken a more structured approach to intellectual property in the AI era. The EU has established specific provisions for text and data mining, TDM, under the Directive on Copyright and Related Rights in the Digital Single Market, DSMD. This framework provides clearer guidelines for AI developers, potentially reducing legal uncertainty. Article 4.3 of the DSMD allows for TDM of lawfully accessible works for both commercial and non-commercial purposes, provided the entity has legal access. However, rights holders have the option to opt out of this usage. This provision strikes a balance between enabling AI innovation and protecting the interests of content creators. Notably, the EU's approach creates a more permissive environment for academic research compared to the US. The DSMD does not allow rights holders to opt out of TDM conducted for scientific research purposes. This provision ensures that researchers can access and analyze large data sets without fear of legal repercussions, potentially accelerating scientific progress in AI. The EU's regulatory framework extends beyond its borders through the AI Act, which requires providers of general-purpose AI models to comply with EU copyright laws, even if the model is trained outside the EU, as long as the output is used within the EU market. This extraterritorial reach emphasizes the need for AI developers to navigate complex international legal frameworks, as they must adhere to both the laws of the jurisdiction where the training occurs, and EU laws if the outputs are utilized in the EU. These divergent approaches have significant implications for AI companies operating on both sides of the Atlantic. Many firms are adapting their practices to comply with the differing legal requirements in the US and EU. For instance, OpenAI has proactively established agreements with content providers like AP News and Shutterstock to license news stories for training AI models. This approach reflects a growing recognition of the importance of compliance and data practices and may become more common as companies seek to navigate the complex legal landscape. The contrasting regulatory environments also create the potential for regulatory arbitrage. Companies may choose to operate in jurisdictions with more favorable laws for AI development, leading to a fragmented regulatory landscape. This situation could complicate compliance efforts and potentially undermine protections for rights holders as companies exploit differences in IP laws between the US and EU. Expert opinions on these divergent approaches highlight the trade-offs involved. While the US model offers more freedom for innovation, it also leads to greater legal risks for developers. The lack of clear guidelines can result in costly litigation and uncertainty about the legality of AI training practices. On the other hand, the EU's structured approach may limit some innovative practices but provides clearer guidelines for compliance. This clarity can be beneficial for both developers and rights holders in navigating the complexities of IP law in the AI era. As these different approaches play out, a crucial question emerges. Which strategy will prove more successful in fostering AI innovation while protecting creators' rights? The answer may lie in the long-term impacts of these divergent approaches on the AI industry and broader innovation ecosystem. Some experts predict that the EU's more structured approach may provide a more stable foundation for AI development in the long run. By offering clearer guidelines and specific provisions for TDM, the EU framework could reduce legal uncertainty and encourage responsible innovation. This approach may also lead to more collaborative relationships between AI companies and content creators, as exemplified by the licensing agreements established by companies like OpenAI. However, others argue that the US model's flexibility could ultimately prove more advantageous for AI innovation. The fair use doctrine allows for more experimentation and adaptation to rapidly evolving technologies. While this approach may lead to more legal challenges in the short term, it could also result in groundbreaking advancements that might be hindered by more rigid regulations. While legal battles rage and regulations evolve, a surprising third option has emerged that could bridge the divide between AI innovators and rights holders. This alternative approach doesn't rely on court rulings or government mandates, but instead proposes a voluntary agreement among industry players. Enter the data scraping code of conduct, a concept that's both promising and controversial. The idea of a voluntary code of conduct for data scraping in AI development has gained traction as a potential solution to the ongoing tensions between AI companies and content creators. This approach aims to establish broadly applicable provisions while providing specific guidelines for different actors in the AI ecosystem. By addressing the distinct roles of AI data aggregators and users of scraped data, such a code could offer a flexible framework that adapts more quickly to the rapidly changing landscape of AI technology. One of the key advantages of a voluntary code is its potential to assist policymakers by allowing for a degree of flexibility and swiftness in implementation. Governments could endorse the code and create a registry of organizations that have adopted it, providing a mechanism for monitoring adherence. This approach could prove particularly valuable in an industry where technological advancements often outpace traditional legislative processes. The proposed code of conduct draws inspiration from existing frameworks, such as the OECD Guidelines for Multinational Enterprises on Responsible Business Conduct. These guidelines offer a voluntary framework for expectations on business behavior, which could serve as a model for developing a data scraping code of conduct tailored to the AI industry. Central to the effectiveness of such a code would be provisions addressing various scenarios, including circumstances when a person or entity violates the code. This could include remediation measures or protocols for when an entity chooses to stop complying with the code. By establishing clear consequences and processes, the code aims to create a self-regulating ecosystem that promotes responsible data practices. Transparency and documentation practices form another crucial component of the proposed code. The OECD report suggests that the code could include recommendations for how organizations should document their data collection and usage practices. This increased transparency could help build trust between AI developers and content creators, as well as provide valuable information for regulators and the public. Education and awareness-raising efforts would play a significant role in the success of a voluntary code. The report highlights the importance of empowering stakeholders with information on how to protect and manage their rights. This includes educating AI system users about responsible usage and helping content creators understand how their work might be utilized in AI training. To ensure the code promotes fair competition and innovation, the OECD report emphasizes the need for a broad and diverse set of stakeholders to contribute to its development. This collaborative approach would bring together rights holders, researchers, AI developers, civil society, and policymakers to create a code that balances the interests of all parties involved. The concept of a data scraping code of conduct isn't without precedent. Successful industry self-regulation examples, such as the International Federation of Reproduction Rights Organizations Code of Conduct for Reproduction Rights Organizations, could serve as a model for the proposed AI data scraping code. These existing frameworks demonstrate the potential for voluntary agreements to effectively govern complex industry practices. To further strengthen the code's foundation, it could incorporate standard definitions and principles modeled after established guidelines like the OECD AI principles. By aligning with these widely recognized standards, the code would encourage responsible innovation while safeguarding privacy, intellectual property, and other fundamental rights. However, the path to implementing a voluntary code of conduct is not without challenges. Critics argue that without legal enforcement mechanisms, compliance may be inconsistent or ineffective. There are concerns that bad actors could simply ignore the code or use superficial compliance as a shield against more stringent regulations. Moreover, the global nature of AI development raises questions about how a voluntary code would be applied across different jurisdictions. While the flexibility of a voluntary approach could allow for easier international adoption, it may also lead to inconsistencies in implementation and enforcement. Another potential limitation is the risk of the code being dominated by larger, more established players in the AI industry. Smaller companies and startups might find themselves at a disadvantage if the code's requirements are too burdensome or if they lack the resources to participate fully in its development and implementation. Despite these challenges, support for a data scraping code of conduct has been growing among various stakeholders. Many AI companies see it as a way to demonstrate their commitment to ethical practices without stifling innovation. Content creators and rights holders view it as a potential compromise that could protect their interests while allowing for technological progress. However, not everyone is on board with the idea. Some privacy advocates argue that a voluntary code doesn't go far enough in protecting individual rights, while certain AI researchers worry that it could inadvertently create barriers to important scientific work. As debates over voluntary codes and legal challenges continue, a technological revolution is quietly unfolding that could put control directly in the hands of creators. What if there was a way to empower rights holders without relying on legal battles or industry agreements? Enter the realm of technical safeguards, a promising frontier in the ongoing struggle to balance innovation and intellectual property rights in the age of AI. The concept of technical tools for managing data access is gaining traction among policymakers and industry experts alike. These tools aim to provide rights holders with greater control over how their data is accessed, used, and shared in the context of AI training. The OECD's recommendation on enhancing access to and sharing of data, EASD, explicitly calls on member countries to foster the adoption of these technical tools, including data access control mechanisms and privacy-enhancing technologies. One of the most widely recognized technical tools in this space is the robots.txt protocol. This simple text file placed on a website's server informs web crawlers about which parts of the site should not be scraped. While robots.txt has been around for years, its effectiveness in preventing unauthorized data collection for AI training has been limited. Many web domains fail to configure their robots. ext files correctly to reflect contractual restrictions, and its voluntary nature means that less scrupulous actors can simply ignore it. However, recent research indicates a shift in how websites are approaching AI-related data scraping. Since mid-2023, there has been a noticeable increase in the number of web domains adopting robots, TXT files, specifically to address AI scraping concerns. This trend suggests a growing awareness of the need for technical safeguards, even if their implementation remains inconsistent. Beyond robots.txt, more sophisticated access control mechanisms are being developed. These include conditional access tools that permit data access subject to specific terms and conditions. For example, a rights holder could specify which users are authorized to access their data and under what circumstances. Policymakers are encouraging stakeholders to explore tools that would allow rights holders to easily communicate these conditions across multiple platforms, streamlining the process of managing data access for AI training purposes. Automated contracting tools represent another promising avenue for empowering rights holders. These systems could make commitments and understandings more easily enforceable by automating the process of creating and monitoring contract compliance. This would not only simplify the process of granting access to data, but also make it easier for rights holders to seek redress if their terms are violated. The potential for direct payment mechanisms is also being explored. These tools could facilitate efficient transactions between rights holders and AI developers, allowing for compensation not just for initial data use, but also for permitted downstream applications. Such a system could create new revenue streams for creators while providing AI companies with clear legal access to valuable training data. Implementing these technical safeguards at scale presents significant challenges. The sheer volume of data involved in AI training, combined with the diverse nature of content creators and rights holders, makes standardization difficult. There's also the question of interoperability, ensuring that these tools work seamlessly across different platforms, AI systems, and jurisdictions. Despite these challenges, there are already examples of successful rights management technologies in action. The EU's AI Act, for instance, requires providers of general-purpose AI models to implement policies that align with EU copyright laws. This includes using state-of-the-art technologies to identify copyrighted works and comply with the text and data mining opt-out mechanism established in the Digital Single Market Directive. The potential for these technical tools to enable new business models is particularly exciting. By providing granular control over data access and use, these safeguards could facilitate more nuanced licensing agreements. Content creators could, for example, offer different tiers of access to their work for AI training with varying price points and usage restrictions. This could create a more dynamic marketplace for AI training data, benefiting both rights holders and AI developers. As these technologies continue to evolve, they hold the promise of fundamentally changing the landscape of AI data collection and use. Imagine a future where AI companies can instantly access vast troves of training data with rights holders automatically compensated and their usage preferences respected. This vision of frictionless, ethical data sharing could potentially end the current contentious debates surrounding AI and intellectual property. Expert assessments of the most promising technical solutions are cautiously optimistic. Many believe that a combination of standardized opt-out tools, automated contracting systems, and blockchain-based provenance tracking could form the backbone of a robust rights management ecosystem for AI training data. The development of these tools is seen as crucial for standardizing transparency practices and incentivizing responsible AI data sharing. As we navigate the complex maze of AI data rights, an unexpected ally has appeared on the horizon. Contracts, those age-old guardians of agreements, are being reinvented for the digital frontier. But can these legal instruments really bridge the gap between innovation and intellectual property protection? The answer may surprise you. Standard contract terms are emerging as a powerful tool to chart a responsible path for data scraping in the AI era. These terms provide optional starting points while allowing organizations to negotiate specific conditions tailored to their unique needs. This flexibility is crucial in a rapidly evolving field where one-size-fits-all solutions often fall short. The development of these standard contract terms is not happening in isolation. It's a collaborative effort involving multiple stakeholders, ensuring that diverse perspectives are considered. This inclusive approach aims to create terms that are applicable across various use cases, from nonprofit research to commercial applications. By bringing together different voices, the resulting contracts have a better chance of addressing the complex realities of AI data use. Policymakers around the world are taking notice of this contractual approach. In the United States, United Kingdom, and Japan, there's growing recognition of the potential for contracts to help manage data rights and reduce disputes related to data scraping. This is particularly important as the legal landscape continues to evolve, often at a pace slower than technological advancements. We're already seeing this trend play out in the tech industry. Major platforms such as the New York Times, X, formerly Twitter, and Zoom have updated their terms of service to specifically address AI data scraping. This move towards more explicit contractual agreements signals a shift in how companies are approaching the use of their data in AI training. OpenAI, a leader in AI development, has taken this approach a step further. They've established agreements with prominent content providers like AP News, Shutterstock, News Corp, and the Financial Times. These formal licensing arrangements for AI training data acquisition may include copyright licenses and access to data. This approach demonstrates a proactive stance in addressing intellectual property concerns and could set a precedent for the industry. However, contracts alone are not a silver bullet. The Global Partnership on AI, GPAI IP Advisory Committee, emphasizes that standard contract terms should be complemented with codes of conduct, technical tools, and education. This multifaceted approach ensures responsible AI data and model sharing, creating a more robust framework for ethical AI development. One of the key advantages of using standard contract terms is their potential to prevent unfair treatment of individuals and smaller enterprises. This aligns with the OECD's recommendation on enhancing access to and sharing of data, which recognizes the importance of equitable practices in data sharing. By providing a standardized starting point, these terms can help level the playing field in negotiations between data providers and AI developers of all sizes. As we look to the future of AI development, the role of contracts in managing data rights is likely to grow. However, this growth comes with its own set of challenges. Creating contracts that work across different jurisdictions is no small feat, given the varying legal landscapes and approaches to intellectual property rights around the world. The concept of smart contracts, powered by blockchain technology, offers an intriguing possibility for automating rights management in AI data use. These self-executing contracts could potentially streamline the process of granting and revoking data access, ensuring compliance with agreed-upon terms, and even facilitating payments to rights holders. While still in its early stages, this technology could revolutionize how we manage data rights in the AI ecosystem. As the field of AI data licensing matures, we're beginning to see emerging best practices. These include clear definitions of permitted uses, mechanisms for attribution and transparency, provisions for updating or revoking access, and fair compensation models. Some innovative licensing models are exploring tiered access, where different levels of data use are permitted based on the specific needs and commitments of the AI developer. Raising awareness about IP issues and data scraping is critical in this evolving landscape. It empowers stakeholders with information on how to protect and manage their rights effectively. This education component is essential for the success of any contractual approach to AI data rights. Technical tools that protect IP rights and enable rights holders to control access to their data more easily are also being encouraged. These include data access control mechanisms, and automated contract monitoring systems. When combined with well-crafted contracts, these tools can create a robust ecosystem for responsible AI data use. Just as the industry starts to find its footing with contracts and tools, Europe throws a curveball. The EU AI Act is poised to redefine the global AI landscape, introducing comprehensive requirements that could reshape how companies approach data collection and model training. At its core, the EU AI Act mandates that providers of general-purpose AI models implement policies that align with EU copyright laws. This includes using state-of-the-art technologies to identify copyrighted works and complying with the text and data mining opt-out mechanism established in the Digital Single Market Directive. But the Act goes further, requiring these providers to publicly disclose detailed summaries about the datasets used for training their models. This transparency requirement is a game changer. AI companies will need to list the main data collections or sets used in training and provide narrative explanations about other data sources. For rights holders, this level of disclosure is expected to enable more effective exercise of their rights. It's a stark contrast to the often opaque practices that have dominated the AI industry thus far. Perhaps most striking is the Act's extraterritorial reach. AI models trained outside the EU must comply with EU copyright laws if their outputs are used within the EU market. This provision underscores the need for internationally coordinated approaches to copyright in the AI era and could have far-reaching implications for global AI development. To help standardize compliance practices across the industry, the EU AI Office is developing a general-purpose AI code of practice. This guidance will focus on transparency and copyright-related obligations under the Act, providing a roadmap for companies navigating these new waters. The Act's emphasis on transparency is expected to lead to better data provenance practices. This could help mitigate legal risks associated with data scraping and improve compliance with intellectual property rights. However, it also raises concerns about the potential impact on innovation and competitiveness. Critics argue that the extensive documentation and transparency requirements could slow down AI development, particularly for smaller companies and startups that may lack the resources to fully comply. There's also the risk that detailed disclosures could expose proprietary information, potentially undermining companies' competitive advantages. On the other hand, proponents of the Act argue that these measures are essential for building trust with users and rights holders. By clarifying the origins of training data and the rights associated with it, the Act could help create a more stable and ethical foundation for AI development. The global implications of the EU AI Act cannot be overstated. Many experts believe it could set a new global standard for AI governance, much like the GDPR did for data protection. As other jurisdictions grapple with similar issues, they may look to the EU's comprehensive approach as a model. This potential for global influence is already affecting how major AI companies operate. Tech giants like OpenAI and Google are preparing for compliance by updating their data management practices. They're forming partnerships with content providers to ensure legal access to training data, a strategy that could become increasingly common as the Act's implementation date approaches. For AI developers, navigating the EU AI Act's data requirements will require a multifaceted approach. First and foremost, companies will need to invest in robust data documentation systems. This includes not only tracking the sources of training data, but also maintaining detailed records of how that data is processed and used. Implementing strong data governance policies will be crucial. This involves establishing clear protocols for data acquisition, use, and storage, as well as training employees on compliance requirements. Companies may need to create dedicated teams or roles focused on EU AI Act compliance, similar to how many organizations responded to GDPR. Another key strategy will be proactive engagement with rights holders. By establishing clear agreements and licensing arrangements for training data, companies can reduce legal risks and ensure compliance with the Act's requirements. This may involve developing new business models for data acquisition and use. Technical solutions will also play a vital role. AI companies will need to invest in advanced tools for data provenance tracking, automated rights management, and model documentation. These technologies can help streamline compliance processes and reduce the burden on human resources. Collaboration within the industry could prove invaluable. By working together to develop best practices and shared resources for compliance, AI companies can help ensure a level playing field and reduce individual compliance costs. This could involve participating in industry associations, contributing to open source compliance tools, or engaging in public-private partnerships focused on AI governance. As AI systems churn out paintings, novels, and music, they're composing a legal puzzle that even the most advanced algorithms can't solve. Who truly owns AI-generated art? This question is at the heart of a new frontier in intellectual property law, one that challenges our traditional notions of creativity and authorship. The rise of generative AI has introduced complex challenges to the intellectual property landscape. Many jurisdictions currently require human involvement for copyright protection, but the level of human input necessary to obtain such protections remains unclear. This ambiguity extends to the question of who the rights holders would be in cases of AI-generated content. The 2024 AI Index report highlights a critical issue. Popular large language models, LLMs, often generate content that closely mirrors the material on which they were trained, including copyrighted works. This raises significant concerns about potential copyright infringement and the classification of AI outputs as derivative works, especially when substantial similarities to protected materials are observed. A notable legal battle that exemplifies these tensions is the case of Getty Images suing the creators of the AI art tool Stable Diffusion. This lawsuit questions the legality of using copyrighted images to train AI models without permission, bringing to the forefront the complex interplay between AI-generated outputs and existing copyright protections. The legal landscape surrounding AI-generated content varies significantly across jurisdictions. For instance, the Israeli Ministry of Justice has issued an opinion confirming that the fair use exception generally applies to data scraping for AI. With an important caveat, it doesn't apply if the AI model's exclusive purpose is to imitate a single artist. This nuanced approach highlights the difficulty in creating blanket rules for AI and copyright. In the European Union, the Directive on Copyright and Related Rights in the Digital Single Market, DSMD, allows for text and data mining, TDM, of lawfully accessible works for both commercial and non-commercial purposes, provided the entity has legal access. However, rights holders can opt out of this usage, adding another layer of complexity to the legal framework surrounding AI-generated content. The unauthorized use of individuals' voices and likenesses by virtual assistants has raised additional ethical and legal questions. As AI-generated outputs increasingly resemble public figures, concerns about the protection of personal identity in the AI era have come to the forefront. This issue extends beyond copyright into the realm of personality rights and privacy. Many experts argue that current legal frameworks are inadequate to address the challenges posed by AI-generated content. There's a growing call for new legal structures to clarify ownership and rights associated with AI outputs. These new frameworks would need to balance protecting the rights of human creators while fostering innovation in AI technology. The complexity of this issue is further illustrated by considering scenarios where AI systems create truly novel works. If an AI generates a painting in a style never before seen, or composes a piece of music unlike anything in its training data, who owns the rights to that creation? The AI itself? The developers of the AI? The owners of the data used to train the AI? Or perhaps no one at all? Some argue that AI-generated works should enter the public domain immediately, as they lack the human creative spark that copyright law was designed to protect. Others contend that the human input in designing and training the AI system is sufficient to warrant copyright protection for its outputs. The implications of these decisions are far-reaching. If AI-generated content receives strong copyright protection, it could lead to a flood of AI-created works dominating creative industries, potentially crowding out human creators. On the other hand, if such works receive no protection, it might disincentivize investment in AI creative tools, potentially slowing the pace of innovation in this field. Different countries are taking varied approaches to this issue. In the United States, the Copyright Office has stated that it will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. This stance suggests that purely AI-generated works would not be eligible for copyright protection under current US law. In contrast, the European Parliament has called for a harmonized approach to AI and intellectual property rights within the EU. They've suggested that AI-generated works could potentially be protected under copyright law, but that such protection should only apply to works that are the result of a human creative process. As these legal frameworks continue to evolve, they will undoubtedly reshape creative industries. Artists, writers, and musicians may need to adapt their practices, perhaps focusing more on areas where human creativity still holds a clear advantage over AI. AI tools might become more integrated into creative workflows, blurring the line between human and machine-generated content even further. As AI technology advances at a breakneck pace, a new challenge emerges that hits closer to home than ever before. Imagine waking up to find a video of yourself online saying things you never said, or hearing your voice promoting products you've never endorsed. This isn't a dystopian fantasy, it's the reality of AI-powered deepfakes and voice cloning, where seeing and hearing are no longer believing. The concept of personal likeness rights has long been a cornerstone of privacy and publicity law. These rights give individuals control over how their image, voice, and other distinctive characteristics are used, particularly in commercial contexts. But as AI systems become increasingly adept at mimicking human attributes, the boundaries of these rights are being pushed to their limits. Modern AI systems can now generate highly convincing replicas of individuals' voices, faces, and even artistic styles. This capability raises profound questions about identity, consent, and the very nature of what it means to be human in the digital age. The tension between technological innovation and personal rights has never been more apparent, as AI's mimicry abilities challenge existing legal frameworks and ethical norms. Recent controversies have brought these issues into sharp focus. Deepfake videos of celebrities and politicians have gone viral, spreading misinformation and raising alarms about the potential for manipulation in media and politics. Voice cloning technology has been used to create unauthorized audiobooks narrated by famous actors, sparking debates about consent and compensation in the entertainment industry. The potential for misuse of these technologies is vast and concerning. From identity theft and fraud to political manipulation and personal harassment, the malicious applications of AI mimicry pose significant threats to individuals and society at large. Regulating these technologies presents a complex challenge, as lawmakers and policymakers struggle to keep pace with rapid technological advancements. Proponents of stricter controls on AI mimicry argue that robust legislation is necessary to protect individual rights and maintain trust in digital media. They call for clear consent requirements, mandatory disclosure of AI-generated content, and harsh penalties for unauthorized use of personal likenesses. On the other hand, some experts caution that overly restrictive measures could stifle innovation in AI technologies, potentially hampering beneficial applications in fields like education, healthcare, and entertainment. Different industries are grappling with these issues in unique ways. The entertainment sector is exploring new contractual arrangements to protect actors' likeness rights in the age of AI. News organizations are developing guidelines for the use and disclosure of AI-generated content. Social media platforms are implementing detection tools to identify and label deepfakes. The impact of AI mimicry extends far beyond public figures and celebrities. As these technologies become more accessible, everyday individuals may find themselves vulnerable to having their likenesses exploited without their knowledge or consent. This democratization of deepfake technology raises questions about privacy, reputation management, and personal autonomy in the digital realm. Proposed solutions for protecting individual likeness rights are emerging from various quarters. Some advocate for the expansion of existing legal frameworks, such as rights of publicity and privacy laws, to explicitly cover AI-generated content. Others propose technological solutions such as digital watermarking or blockchain-based authentication systems to help verify the authenticity of media content. In the European Union, the concept of moral rights provides a potential framework for addressing AI mimicry. Under Article 6 bis of the Berne Convention, creators have the right to claim ownership of their work and object to modifications that may harm their honor or reputation. This principle could be extended to protect individuals from unauthorized AI-generated representations of themselves. In the United States, the legal landscape is more complex, with protection for likeness and publicity rights varying across jurisdictions. Some states have introduced bills aimed at regulating deepfake technology, while others rely on existing privacy and defamation laws to address these issues. The ethical implications of AI mimicry extend beyond individual rights, raising broader questions about the impact on creative industries and the nature of artistic expression. As AI systems become capable of replicating artistic styles with uncanny accuracy, the lines between inspiration, imitation, and infringement become increasingly blurred. As AI continues to push the boundaries of creativity and innovation, a critical challenge emerges at the intersection of technological progress and intellectual property protection. Can we foster AI development without compromising the rights of creators? The answer may lie in a nuanced approach that's already showing promise in some corners of the world. The tension between AI innovation and IP protection is not just a theoretical concern, it's a pressing issue with real-world implications for creators, tech companies, and policymakers alike. On one side, we have the imperative to advance AI technology, which holds immense potential for solving complex problems and driving economic growth. On the other, there's the equally important need to protect the rights of creators and ensure that their work is not exploited without fair compensation or consent. This balancing act is further complicated by the unique nature of AI development. Unlike traditional forms of innovation, AI often requires vast amounts of data for training, much of which may be protected by copyright or other forms of IP. Restricting access to this data could significantly hamper AI progress, but allowing unfettered use risks undermining the very systems designed to incentivize creativity and innovation. The OECD report on this topic emphasizes the need for a balanced approach that fosters innovation while protecting creators' rights. It suggests that many existing IP laws, which often predate modern AI practices, need to be updated to reflect the realities of AI development and data scraping. This highlights the challenge facing policymakers: how to modernize legal frameworks without stifling the rapid pace of technological advancement. One potential solution proposed in the report is the development of standard contract terms to help manage the complexities of data scraping and IP rights. These terms could serve as a starting point for negotiations between AI developers and rights holders, allowing for flexibility while ensuring compliance with IP laws. This approach recognizes that a one-size-fits-all solution is unlikely to work in the diverse and rapidly evolving field of AI. The economic implications of IP regulations in the AI space are significant and multifaceted. Overly strict regulations could create barriers to entry for smaller AI companies, potentially concentrating power in the hands of a few large tech giants with the resources to navigate complex legal landscapes. On the flip side, lax regulations could lead to widespread IP violations, undermining the economic incentives for creators and potentially reducing the quality and diversity of available content. Experts in the field suggest that achieving an optimal balance requires collaboration among various stakeholders, including rights holders, AI developers, and policymakers. This collaborative approach can help create a regulatory environment that supports both innovation and the protection of IP rights. It's not just about setting rules, it's about fostering an ecosystem where all parties can thrive. Some jurisdictions are already experimenting with innovative approaches to this challenge. For example, the OECD report indicates that successful policy approaches in other areas have included the establishment of clear guidelines for data scraping and the implementation of transparency measures. These measures allow rights holders to understand how their data is being used, fostering trust and cooperation between creators and AI developers. The European Union's AI Act provides an interesting case study in this regard. The Act introduces compliance obligations for AI providers, requiring them to disclose detailed information about the datasets used for training their models. This approach aims to enhance transparency and protect the rights of data creators while still allowing for innovation in AI development. Another promising avenue highlighted in the OECD report is the standardization of technical tools for data access control. These tools can empower rights holders to manage their data more effectively while facilitating compliance for organizations that collect or use scraped data. By providing creators with more control over how their work is used, these tools could help strike a balance between protection and innovation. Education and awareness-raising efforts are also crucial in this balancing act. The OECD emphasizes the importance of informing both rights holders about their protections and AI developers about responsible data usage. This knowledge-sharing approach can help prevent unintentional IP violations and foster a culture of responsible innovation in the AI community. As we look to the future, it's clear that finding the right balance between IP protection and AI innovation will require ongoing effort and adaptation. However, emerging best practices offer hope for a path forward. These include the development of flexible licensing models, the use of transparent AI training practices, and the creation of collaborative platforms where creators and AI developers can work together to address concerns and find mutually beneficial solutions. While emerging best practices offer hope for balancing innovation and rights protection in the AI era, a groundbreaking approach is gaining traction that could revolutionize how we navigate these complex issues. Enter the multi-stakeholder model for AI governance, a collaborative framework that brings together diverse voices to shape the future of artificial intelligence. This approach represents a significant departure from traditional top-down regulation. Instead of relying solely on government bodies to dictate rules, the multi-stakeholder model seeks to create a more dynamic and responsive system. It recognizes that the challenges posed by AI are too complex and fast-moving for any single entity to address alone. At the heart of this collaborative approach is the development of a data scraping code of conduct. The OECD report highlights the importance of involving a wide range of stakeholders in crafting this code, including rights holders, researchers, AI developers, civil society organizations, and policymakers. By bringing these diverse perspectives to the table, the aim is to create guidelines that are both practical and comprehensive. This inclusive approach has already gained traction at the highest levels of international cooperation. The G7 has adopted a voluntary code of conduct that emphasizes the need for appropriate data input measures and protections for personal data and intellectual property. This initiative underscores the growing recognition that collaborative efforts are essential to address the challenges posed by AI and data scraping. The multi-stakeholder model draws inspiration from successful frameworks in other areas of tech policy. The OECD guidelines for multinational enterprises, for instance, provide a template for voluntary, government-backed standards of business behavior. These guidelines include expectations for companies to implement safeguards that prevent adverse impacts related to intellectual property rights. One of the key advantages of a collaborative approach is its potential to establish broadly applicable provisions while still allowing for specific guidelines tailored to different actors in the AI ecosystem. This flexibility is crucial given the diverse range of stakeholders involved, from small startups to tech giants, from individual creators to large rights-holding organizations. However, implementing a multi-stakeholder model is not without its challenges. Aligning the interests of such a diverse group of stakeholders can be a complex and time-consuming process. There may be conflicts between the desire for open access to data for AI training and the need to protect intellectual property rights. Finding common ground on issues like fair compensation for data use or acceptable limits on data scraping can require delicate negotiations and compromises. Despite these challenges, there are promising examples of successful multi-stakeholder approaches in the tech world. The development of internet governance protocols, for instance, has long relied on input from a diverse range of stakeholders, including tech companies, civil society organizations, and governments. This model has allowed for the rapid evolution of internet standards while still addressing concerns about security and stability. In the context of AI and data scraping, a multi-stakeholder approach could help address some of the most pressing issues at the intersection of innovation and intellectual property protection. For example, it could lead to the development of standard contract terms that serve as optional starting points for organizations while still allowing for negotiation of specific conditions tailored to different use cases. The OECD report also emphasizes the need for a coordinated approach to address the challenges of data scraping across jurisdictions. This includes developing standard definitions and terminology to facilitate compliance with IP laws and promote a shared understanding among stakeholders. A multi-stakeholder model is well suited to this task, as it can bring together experts from different legal systems and cultural contexts. Technical solutions could play a crucial role in implementing the outcomes of multi-stakeholder discussions. The OECD report discusses the importance of tools that can help protect IP rights and enable rights holders to manage access to their data more effectively. These could include data access control mechanisms and automated contract monitoring systems. By involving both tech developers and rights holders in the design of these tools, a multi-stakeholder approach could ensure they are both effective and user-friendly. Education and awareness-raising efforts are another key component of successful multi-stakeholder initiatives. By fostering a shared understanding of the challenges and potential solutions, these efforts can help build trust between different stakeholder groups and increase buy-in for collaborative approaches. As we look to the future of AI governance, the multi-stakeholder model offers a promising path forward. It provides a framework for addressing complex issues in a way that is flexible, inclusive, and responsive to rapid technological change. While it may not be a silver bullet for all the challenges posed by AI and data scraping, it represents a significant step towards more balanced and effective governance. As the AI landscape evolves at breakneck speed, the legal and ethical challenges surrounding intellectual property rights create a complex minefield for professionals in the field. While collaborative frameworks and governance models adapt, individual AI developers and data scientists face a pressing question: how can they protect themselves and their work in this rapidly changing environment? The current state of AI IP law is marked by uncertainty and inconsistency across jurisdictions. Existing intellectual property laws often predate modern AI practices, creating a disconnect between legal frameworks and technological realities. This mismatch poses significant risks for AI professionals who must navigate a patchwork of regulations that vary widely in their application to data scraping and AI training. Adding to this complexity is the breakneck pace of AI development. As new models and techniques emerge almost daily, the gap between innovation and regulation continues to widen. This creates a precarious situation where AI professionals may inadvertently run afoul of intellectual property laws, even as they push the boundaries of what's possible in machine learning and artificial intelligence. In this challenging landscape, AI professionals must adopt proactive strategies to mitigate legal risks. One crucial approach is to implement robust data management practices. This includes carefully documenting the sources of all data used in AI training, ensuring proper licensing agreements are in place, and maintaining clear records of how data is processed and utilized. By establishing a comprehensive data provenance system, AI developers can demonstrate due diligence and transparency in their work. Another key strategy is to prioritize ethical considerations in AI development. This means going beyond mere compliance with existing laws and actively seeking to uphold principles of fairness, accountability, and transparency. AI professionals should consider the potential impact of their work on intellectual property rights and take steps to minimize harm to content creators and rights holders. Staying informed about evolving regulations is paramount for AI professionals. The legal landscape surrounding AI and intellectual property is in constant flux, with new cases and precedents emerging regularly. By keeping abreast of these developments, AI developers can anticipate potential legal challenges and adapt their practices accordingly. This may involve regularly attending industry conferences, participating in professional development courses, and engaging with legal experts specializing in AI and intellectual property law. Expert advice on best practices for responsible AI development emphasizes the importance of collaboration and open communication. AI professionals should actively engage with stakeholders, including content creators, rights holders, and policymakers, to address concerns and find mutually beneficial solutions. This collaborative approach can help build trust and foster a more sustainable ecosystem for AI innovation. The potential career implications for data scientists and AI professionals in this evolving landscape are significant. As the intersection of AI and intellectual property becomes increasingly complex, professionals with expertise in navigating these challenges will be in high demand. This creates both opportunities and risks for those in the field. Looking ahead, several key skills will be crucial for AI professionals to thrive in this new landscape. First and foremost is a deep understanding of intellectual property law as it applies to AI. This doesn't mean becoming a lawyer, but rather developing a working knowledge of copyright, patent, and trade secret principles and how they impact AI development. Secondly, expertise in data ethics and governance will be essential. AI professionals who can demonstrate a commitment to ethical data practices and a thorough understanding of data privacy regulations will have a significant advantage in the job market. Technical skills in data provenance and rights management tools will also be highly valued. As automated systems for tracking and managing intellectual property rights become more prevalent, proficiency in these technologies will be crucial for AI developers. Additionally, strong communication and collaboration skills will be vital. The ability to work effectively with legal teams, explain complex technical concepts to non-technical stakeholders, and contribute to policy discussions will set apart the most successful AI professionals. To future-proof their AI careers, professionals should take several key steps. First, invest in ongoing education and professional development, particularly in areas related to AI ethics, intellectual property law, and data governance. Second, actively seek out opportunities to work on projects that prioritize responsible AI development and ethical data practices. This hands-on experience will be invaluable as the industry continues to evolve. Third, build a network of peers, mentors, and experts in both the technical and legal aspects of AI. This network can provide support, guidance, and opportunities as you navigate the complex intersection of AI and intellectual property. Fourth, consider obtaining certifications or specialized training in AI ethics and compliance. As regulations around AI development become more stringent, formal credentials in these areas may become increasingly important for career advancement. Finally, stay actively engaged in industry discussions and policy debates surrounding AI and intellectual property. By contributing to these conversations, AI professionals can help shape the future of the field and position themselves as thought leaders in responsible AI development. As the world grapples with the rapid advancement of artificial intelligence, a critical question emerges. Can nations unite to govern AI on a global scale, or are we headed towards a fragmented future? The answer to this question could reshape the entire technological landscape, with far-reaching implications for innovation, intellectual property rights, and international cooperation. The need for international cooperation in AI governance has become increasingly apparent, particularly when it comes to addressing the challenges posed by data scraping and intellectual property rights. The OECD report emphasizes that a coordinated approach is essential to navigate the complexities of AI and IP laws across different jurisdictions. This recognition extends beyond academic circles, with world leaders taking note of the pressing issues at hand. During Japan's G7 presidency in 2023, the infringement of IP rights was identified as a significant risk stemming from generative AI. This acknowledgement by G7 leaders signals a growing awareness of the need for global governance frameworks to address these challenges. However, the path to international cooperation is fraught with obstacles, not least of which is the current geopolitical climate. One of the primary hurdles in establishing a unified global approach to AI governance is the inconsistency of existing IP laws across jurisdictions. Many of these laws predate modern AI practices, complicating their application to data scraping activities. This discrepancy creates significant challenges for harmonizing AI governance on a global scale, as different countries may interpret and apply these laws in vastly different ways. The European Union has taken a proactive stance with its AI Act, which introduces compliance obligations for providers of general-purpose AI models. Notably, these requirements extend beyond EU borders, mandating adherence to EU copyright laws even if the model is trained outside the EU, provided the output is used within the EU market. This extraterritorial reach underscores the need for coordinated copyright approaches across jurisdictions and highlights the potential for regulatory conflicts. Adding to the complexity is the lack of universally accepted definitions for terms related to data scraping and AI. The OECD report notes that this absence of standardized terminology complicates international discussions and agreements. Establishing common definitions could facilitate better communication and cooperation among countries, paving the way for more effective global governance strategies. Experts predict that the future of global AI governance will hinge on the ability of countries to collaborate and establish common frameworks that balance innovation with the protection of intellectual property rights. However, achieving this balance is no small feat given the diverse interests and priorities of different nations. The potential consequences of a fragmented regulatory landscape for AI governance are significant. Without coordinated efforts, the global AI industry may face increased legal uncertainties and compliance challenges. This could lead to a situation where AI models are legal in one country but criminal in another, creating a complex web of restrictions and permissions that companies must navigate. To address these challenges, the OECD recommends that policymakers consider developing flexible and voluntary measures that can accommodate diverse legal and regulatory approaches across jurisdictions. These measures could help address the challenges posed by data scraping in an internationally coordinated manner while allowing for some degree of national autonomy. Ongoing litigation related to data scraping is on the rise globally, with significant cases emerging in the United States and the EU. This trend indicates that the legal landscape surrounding AI and IP rights is evolving rapidly and requires careful monitoring. The outcomes of these cases could set important precedents for how AI governance is approached on an international scale. Despite the challenges, there are emerging frameworks for international AI cooperation that offer hope for a more unified approach. Multi-stakeholder initiatives, such as those proposed by the OECD, bring together diverse voices from government, industry, academia, and civil society to craft governance solutions. These collaborative efforts represent a departure from traditional top-down regulation and may provide a more flexible and inclusive approach to global AI governance. The development of technical tools and standards also plays a crucial role in facilitating international cooperation. Standardized data access control mechanisms, automated contract monitoring systems, and tools for communicating data access conditions across multiple platforms could help create a more cohesive global framework for AI governance. Education and awareness-raising efforts are another critical component of successful international cooperation. By empowering stakeholders with knowledge about IP issues and data scraping, these initiatives can help bridge the gap between different jurisdictions and foster a shared understanding of the challenges and potential solutions. As we conclude our exploration of AI and intellectual property, it's clear that we're navigating a complex and rapidly evolving landscape. The OECD highlights the need for a coordinated approach to address the challenges posed by generative AI in the intellectual property realm. With increasing litigation and calls for policy measures, the legal framework surrounding AI and IP is in constant flux. Looking ahead, ongoing dialogue among stakeholders will be crucial to ensure that AI development aligns with both intellectual property rights and ethical standards. This balance is essential for fostering innovation while protecting creators. As AI professionals, staying informed about these developments and actively participating in discussions will be key to shaping responsible AI practices. The future of AI governance will depend on our ability to collaborate across borders and establish common frameworks that address the unique challenges of this transformative technology. By engaging with these issues and contributing to ethical AI innovation, we can help steer the course towards a more equitable and innovative future.